Okay, so I guess we can start, and so that the people on the stream could hear us all right. Whenever you want to say something, I will come to you and give you the microphone so that we can discuss this. And yes.
I wanted to propose that Thomas Gau will lead through the discussion.
Okay.
Because we propose
Yes.
amendments.
Okay. So this is just that we need everybody who wants to say something needs to use the microphone so that the remote delegates see it. Okay. So use the microphone.
So hello. No problem. So we're still waiting for some help for the video beamer. Could someone in between? Good. So let's have a start, because we do have 21 proposals today, grouped into 4 areas. The first one is conceptual changes containing 4 proposals for amendments. So, membership for all organizations. So you can also see it on the wall. Current wording: members of Pirate Parties International can become parties and party-related organizations that do not have the goal of participating in elections. There is a proposal from the Pirate Party of Czech Republic, who may have the microphone in a second they can propose their own draft.
Hello, I'm Jakub Michalek of the Czech Pirate Party, and we propose to change the current wording, which says there are basically two subjects that can join the Pirate Parties International, which are parties, and second, party-related organizations that do not have the goal of participating in elections. So it's very hard to define what a party-related organization is. Like, for instance, Free Software Foundation and organizations like that are definitely not party-related organizations because they have nothing to do with political parties. And we would like these organizations to join the PPI as observer members. Please say to the microphone.
I talked to Richard Stallman by email, and he is interested in becoming an observer member. I asked for the paperwork so that he could apply. I've redirected that information, but nothing happened.
Okay, so I guess we can start the discussion. So what we now propose is a general change of statutes. It's not related to like one concrete member, but we think that it would be better if the membership, which is always decided upon by the General Assembly, it would allow broader, I would say, set of organizations to take part in the PPI through the observer membership, not only party-related organizations. We don't think that this is the correct wording.
Thank you very much for your proposal. Any questions to Jakob?
Stefan Reinover, Austria. By the way, we just preached the current statutes a few minutes before when we accepted the Bavarians and the Hessens as observer members. And I strongly am for this change because, for example, our student organization wouldn't be able otherwise to become an observer member next year eventually. Because our student organization is also a political party, which is just running on university elections, but nonetheless running in elections.
Thank you again. Anybody else? Questions?
One more thing that is that the current wording doesn't include objects of law that are not parties technically, but that have the goal of becoming parties and participate in elections, or that even do not have to be parties in order to take part in the elections, which are, for instance, associations that can provide certain services for independent candidates in countries where the law conditions for establishing a political party are harsh and are hard to meet.
Thank you. So do you want to have that as an addition to it at the moment for today? Do you want that as an addition for the text, the proposal itself for today? That's what I've heard over here. That's what I've. Okay. No problem. That's what I asked. That's what I asked. So, yeah, any further questions? So no further questions, so we can continue SAP 2, ordinary members. Conceptual change, two proposals, one from the Power Party of Czech Republic, one from Luxembourg. The current wording, to ordinary membership are eligible members that A, adhere to the statutes and the goals of the association as laid down by these statutes. Proposal A, by the Czech Republic, adhere to the statutes, and B, are parties. So, Czech Republic again, first.
Sorry, I'm not sure whether is it. Yes. Okay, I think it's switched, but we can see it in the pirate, but it's irrelevant. Yes. Yes, but okay. So this is a rather complicated thing because there are criteria for the members to join. They are listed in the Article 4 of the statutes in paragraph 1, and for ordinary membership, what we want to say very clearly that for ordinary membership, only those that are parties are eligible. Those that have that are constructed as political parties, not necessarily recognized by law, but which are parties, are eligible to the ordinary membership, as opposed to the second category of observer membership. So I think that what is the problem of what I think, and I guess Jerry will continue on this, of the alternative A, is that it says that they should adhere to these statutes, but these are the criteria for the ordinary membership, and of course the condition that the member should adhere to the statutes should be for all members, not only the ordinary membership. So this, if there is the condition to behave according to the statutes, this should be listed for all members, and it is incorrect to list it under the ordinary membership separately, because it is not specific to ordinary membership.
I agree with Jakub. So when I submitted it, I didn't see that, and I see Jakub's proposal, and I agree with him.
So, thank you both. Any other questions on that?
I'd like to listen someone that disagree to the amendments, just for debating, no?
I'm not totally disagreeing, but you said parties which are not still legally parties, but in the process of becoming parties, like the Slovenians. But the wording is are parties. So at least we would have to have a separate movement on an agreement of understanding that in our interpretation that includes parties which are in the process of becoming a legal party. Because otherwise, that's stuff for the arbitrary court.
Yes, I think that has already been done, because like it's recognized right now that there are certain groups that are not yet legally parties, but they are already members of the PPI. Like at the last conference, there were many of these, and I think that this is a generally accepted fact that the parties mean just like any organization that has like the structure and.
A creed fact is something different from having a statement that it's a creed fact. Is it just informally a creed fact, or is there a manifesto, a resolution, whatever, that it's a creed fact?
Okay, so I know it's vague, but it's vague from the very beginning. It's very loose. Like the conditions, if somebody is a party, is still left on the General Assembly, which accepts all the new members. So I think that this is loose, but it's for the benefit of the General Assembly, which can decide who actually is going to become a member, an ordinary member, because the ordinary membership is like a privileged status.
Yes, exactly, because any other thing would mean that it would fall to the board, for example, to check every application, whether this party is registered, whether it is really a party according to national law, or there would be discussions. What according to what law do we compare the term parties? So it is a vague term, but it's for PPI a more useful term, because also that we have the experience that registering a party can be very, very difficult for certain countries. So if you're putting parties, there might be some interpretation that only registered parties, so also recognized by national law that they are parties, and then we would have a lot of organizations that's not registered that couldn't join, because, for example, they have to collect 5,000 votes or something. And so I think it's much easier to put down parties with the understanding of a very vague and large group.
The sense is very broad, and I think this is important also in the sense not to extend only to registered party, is because it can happen. A situation can happen that you have a pirate party which is dissolved because it's pirate, for instance, and this can happen. When we started in the Czech Republic, they said this is illegal. This is like the political party of the rapist of young children, and this should be dissolved. Okay, so it can happen then the pirate party, and especially for instance in Africa, in regimes where there is not they don't really like enforce the, I would say, free and democratic principles of the competition of political parties. It can happen the party get dissolved and it doesn't exist anymore legally in the legal sense of that national legislation. But in that case, this means that it still is eligible to membership, because we don't want them to lose the membership of the PPI just because they are dissolved by some authoritarian regime or so. So this was the goal, which was behind the very broad formulation of the acceptance criteria as parties.
So thank you again. And again, and other questions on this topic? Nope. So SAP 3, also done by the Czech Republic. Current wording: a board member may resign at any moment. In case of vacancy, a substitute may be appointed by the board until the next General Assembly. If the position of both co-chairman and the chief administrator office is vacant, an extraordinary session of the General Assembly has to be held within the next 6 months. Vacancies among other elected members of the board shall be filled for the remainder of the term still to be served by the resigning or deceased holder of the seat by the runners-up in order of election, at the election in which the resigning or deceased member was elected. So the proposal states out a board member, this paragraph has to be changed to, in a board member may resign at any moment. after resignation, death, long-term disease or other situation in which a member of the board does not execute his functions for more than 3 months, his seat becomes vacant. So, Czech Republic.
So this tries to reflect the problem that the board had to deal with. I'm also a member of the board. Jerry is co-president, of course, member of the board. And the fact was that at like 80% of the meetings of the board, we did not manage to have the quorum. So we could not make decisions. And it was not clear. In the current wording, the vacancy means that person dies, for instance. And only under this condition, he can be replaced. But it can also happen that there are other conditions, like doesn't take part in the meeting of the board and so on. And there is really no mechanism how to replace those people. So I think that this proposal is very it's tied with the proposal of arbitration court, which would have the competence to decide whether a place is vacant. I think it is wrong to give this competence to the board, because the board would have the power to change its own members. So there would be majority in the board. They would just say that this part of the board, they don't work well, and they would replace them with somebody else. I think that this would be quite dangerous to say. So the proposal is to change the term vacancy to include situations of long-term disease or other situation in which a member of the board does not execute his functions for more than 3 months. And under these cases, this could be declared by the court, and he would be replaced by the runner-up or so. Yes.
I have a couple of special cases. For example, during a revolution, a member of the Pirate Party, for example, in Libya, is busy, for 3 months, and this is an example. So the seat become vacant. I understand. Do I understand?
As Jakob described it, it's not the board who decides if it's vacant or not. It will be the court of arbitration. So there, the court of arbitration. We're coming to the court of arbitration in the next amendment. So it would be the court of arbitration's decision whether it is the position is vacant or not, and there it can apply common sense and ask for reasons. And if it's your example, it can apply its judgment and say, well, he has something very useful to do. But if, for example, the court of arbitration sees that this particular board member, for example, just vanished, or it didn't answer any mails, or wasn't in contact with the board, it can say, okay, now it's vacant, and we didn't have any opportunity to get in contact with him, for example. So there, the court of arbitration has the means to go and look into the cases. That's also why it says here, or other situations, which is all, again, very vague. And that's also to avoid situations like yours, where there can be a good reason you're not there, but also to allow to declare a vacancy when there is a good reason.
Yes, thank you. I think that was well explained, and I would like to say once again that the motivation for this is really the situation in which board couldn't take decisions on majority of its meeting because the quorum was not met.
Thank you. Yep.
Yes, I have a question and a comment. This is only about the board, but how about other elected positions like lay auditors and in particular the treasurer? We have an acute problem right now with the treasurer actually missing, not fulfilling his position.
Sorry, the treasurer is a member of the board. But for instance, I think you could use analogy for these. there are specific provisions in other articles that, for instance, for the court of arbitration, you can use analogy for elections considering the board. And I think that we have only, like, the current situation is that the main organ, and I would say the only, like, real organ is the board. Then you have the lay auditors, but they are, like, only from one conference to the other conference. So it stems from the concept of organization that only has conferences, and in the space between the conferences, there is only the board, which actually does the job.
So, thank you. Any further questions? None at all. So let's switch to SAP 4. Also conceptual changes, I believe, one of the major ones. I will read that aloud again, though it's a bit long, but it has to be done, I say. So, depends on vacancies. To accomplish, the current wording, that's 22D, to accomplish these objectives, the association shall, among other things, act as a mediator for any disputes between members if requested to do so. 7.2. The suspension and the exclusion of a member may only be decided by the General Assembly. A proposal for the exclusion of a member may only be submitted by the board or by a tenth of members from 3 different countries. There is a proposal to add 14 continents. Sorry. Proposal now is at 14A, Court of Arbitration, Clause 1. The exclusive power to resolve internal disputes shall be vested to the Court of Arbitration. All other organs and officers are required to cooperate with the Court of Arbitration to the extent needed for the proper exercise of its functions. Clause 2. Complaints may be sent by the organs and officers of the PPI and by the members. A complaint may be regulated with a fee to be returned if the complaint is reasonable. The complainant may participate in the investigation. Clause 3. In particular, the Court of Arbitration has the exclusive power to A. Issue a preliminary ruling in an urgent matter of its competence. B. Declare matters of fact when necessary for the functioning of the PPI. C. Decide the disputes between the officers and the organs of the PPI. D. Decide on the restrictions on persons who breach the statutes and the internal regulations in these cases degrade on official or declare his further incapability to be elected. E. Decide on the validity of legal acts of the organs of the PPI. F. Decide on the matters of membership. Article 7, Clause 2, I believe. Clause 4. The Court of Arbitration keeps a register of mediators. This register lists the name, contact addresses, and party affiliation of the people from the ordinary members who are willing to help solve the disputes between the members. All members may consult this register and choose a mediator who can help them solve the dispute. Clause 5. If the mediation fails, the members or applicants who are in a dispute may present an agreement to the Court of Arbitration which contains the description of the dispute and the consent to abide by the decision of the Court of Arbitration. The Court of Arbitration will decide the dispute within the limits contained in the agreement. Clause 6. The Court of Arbitration may answer the preliminary questions of the organs and individuals about the interpretation of the statutes and the internal regulations. Such answers are through their persuasiveness only. Clause 7. The Court of Arbitration shall have between 3 and 7 members. The provisions concerning the election of the members of the board and vacancies apply accordingly. Change to 2D to D. Act as mediator or arbitrator for any disputes between members if requested to do so. At 3.5. The members are obliged to respect the statutes, internal regulations, and the rules of procedure, in particular, be the implications of the decision of the Court of Arbitration. Change 7.2.2. The decision on the changes of membership, such as suspension, reinstatement, and exclusion, fall within the competence of the Court of Arbitration and can be appealed for the General Assembly. If the member appeals, the decision becomes effective at the end of the meeting of the General Assembly, unless the General Assembly decides otherwise. Proposal of the exclusion of member may only be submitted by the board or by 10th of members from 3 different countries. Don't wonder I write that aloud because it's quite long, and I believe it's important that we all follow up what's in the text itself. So I'll give the word to Czech Republic.
Thank you. So basically the concept that is behind this provision is that there is power within the board, and it is bad if power is unregulated, if there are not organs to control in certain way the legality of the actions, for instance, of the board. That is not under control, that the board may, for instance, do things that are not that are against the statutes. And under current provisions, the only way how to deal with this is at the next conference, which takes 1 year. I think that we all agree that the power needs certain rules that should not be stepped over. That an organ which makes sure that an officer of the PPI is not working against the statutes. We also need an organ that will decide upon the vacancy of a seat, so that the board wouldn't decide in its own cause. I think that the principle that one is not a judge in his own cause is a very important one. So that is why we propose the creation of the Court of Arbitration. So this is the first and the main reason to solve the disputes in the PPI. That is between the board, and the lay auditors, to declare certain facts such as vacancy and so on. And there's also other which is given as a possibility to the members, and it is exclusively on the proposal of the members. You can see that starting at paragraph 4, that it will have a register of mediators that can be used by all the pirate parties. So that is, if there are 2 pirate parties that have disputes, for instance, there are 2 pirate parties in one country and they want to enter the PPI and they cannot agree. So they have the possibility to go to the register and have a person of the PPI help them to form a federation that is necessary according to the current statutes for them to enter the PPI. And these can be other disputes that can arise between the members of the PPI. This can happen, and I think it's important to have a mechanism that would help solve these issues between the pirate parties without accusing themselves in the media, through the media, or through other means. I think that we should do it in a sort of polite and decent way, and choosing a mediator. And in case they want really to decide this thing, for instance, they want to enter the PPI, but they cannot agree upon the conditions, they can both bring their dispute to the Court of Arbitration if they agree, and set the questions that should be decided by the Court of Arbitration. That is, if the mediation fails, which is paragraph 5. I think that the rest is quite clear. But then there one more thing. Sorry, it's at paragraph 3. Article 3, paragraph 5. The members are obliged to respect the statutes, internal regulations, and rules of procedure, in particular, bear the implications of the decisions of the Court of Arbitration. So this is what we were talking before. There is a problem that it is listed there that only the ordinary members should adhere to the statutes. So what we do now is to insert into Article 3 a clause that says that all members are obliged to respect the statutes and internal regulations, because otherwise it would not hold for the observer members, which is a mistake. So it's a legislative mistake, and which is corrected by the by this provision. And last thing is the decisions of the changes of membership. So this makes the criteria for exclusion stricter. It tries to avoid the I would say the democracy is not rule of the mob. So we don't want we want first people who have experience in these things to give their opinion. That is what happens according to the last provision on page 10. We want the Court of Arbitration to see whether the member to give the facts, list them, and say whether the member has breached the statutes and so on. And it will only appeal to the General Assembly in case that this decision is found incorrect. So it makes stricter the criteria for and I think better the criteria for exclusion of members, which I think that we should that exclusion of a member is a very important thing and should not be done as easily as one vote perhaps on a conference without any procedure taking place and listing the circumstances and facts that could be done in the procedure before the Court of Arbitration.
So thank you. There was one question.
So the Court of Arbitration is elected, according to you, between the General Assembly and the Chief Executive. I mean, in which way you propose to elect the Court of Arbitration between the General Assembly and paragraph 7.
Oh, I think that there is a problem with the dependency of the. So this should be discussed before the other amendments because it relies on that. So it can happen a strange situation if one of them get voted and approved without the other one. So I have another question about. The situation you made an example about two period parties from the same countries, but in that case, I think there would be they are not still ordinary members, and if there is already an ordinary member from a country, another one cannot join. I think the cases can be, for example, if there is a fork in a period party, maybe in that case. It will be useful. However, I think in that case, I don't know if it's a good idea to insert directly in the statutes such a fixed things, in the sense that the period party, the two forking factions have to agree and can agree between them to ask the period parties international to assign a mediator, but I don't think there is necessity for a status amendment for that.
Well, according to the statutes, there is no organ that would be competent to do that. So that is a problem. It's not listed among the competencies of the board. Well, you could say it by exegesis of the statutes that it goes to the board, but I think that it's quite a different thing to be done by the board. The board is more like executive organ, and it should not deal with with things that are more related, I would say, to the judicial branch. There is this division between the two lines.
So, well, you made the proposal that the SAP 4 will be handed out beforehand. But, we have the problem that we have a long list for votes. Just a question to Jerry: would it be possible to maybe join 3 and 4 into one, so that they depend on each other? SAP 3 and 4, I would say, because they are interlinked.
Sorry. So every proposal has the dependencies, and it's listed on the page 9 on the top that it depends on the vacancies. So I think that if the vacancy amendment is accepted, it can exist even without the court of arbitration. But it will be the same problem as there was before. There would be no competent organ to. You would have to say that it is the board that does this, which is I think a conceptual mistake. So probably I think that that it should be done in the order of vacancy, and then SAP4, which clearly the court of arbitration depends on proposal of vacancies, because otherwise it would have to be changed.
But technically, even if the vacancies motion wasn't adopted, and you had the mentioning of vacancies in the arbitrary court amendment, you could still make some regulations about vacancies.
Yes. Also, they are independent amendments. If I'm right, so yeah, dependent. Yeah. So if it says depends on vacancies, that means for you that if we vote SAP 3, then we can accept SAP 4. If SAP 3 is not accepted, then we can't accept SAP 4. Just in my opinion, even if they depend, we can still vote them separately. I mean, there are other inconsistencies in the statutes, and also there are two. That's not an argument to get another done, but it's the fact that it says depends on vacancy is for the voters to know. Okay, I have to check both and cross-reference them, and then make up their own mind if they want this inconsistency or not. So I really would vote on them separately and accept or refuse them separately. Who wanted to say something? Was it here? You?
I think that minor changes will have to be done in case of these situations. That you accept if it can of course happen that we accept the other amendment and we don't accept the amendment on which it depends. And I think that in that case we can make small changes that at least help to solve the worst inconsistencies that can happen.
Amendments are fixed in my understanding, but nonetheless, if just the arbitrary court was introduced, it would have the power to rule on what to do on vacancies. Additionally, as said before, we could decide on lower level regulations concerning vacancies.
Well, I have some general questions here. 7. The Court of Arbitration shall have between 3 and 7 members. How do we find out how many that should be, and how do we vote on them? And it's the General Assembly which elects them, right? So if we do that, do we do that tomorrow? I mean, yeah, is this organized? Well, it's not even in the, as far as...
Thanks. No, I realize this too. But first of all, your first question, shall have between 3 and 7 members. That sounds to me like a question. How many members do we want in the Court of Arbitration? And then proposals, raise your hand, vote yes or no. The other question about getting the members of the Court of Arbitration, if this is accepted, we know it tonight, and we have to organize something for tomorrow. So we have to find people who are willing to be an arbitrator, and we have to put them somewhere and get them voted.
What I think is a good thing is that it will be done in the same way as the board. So we really don't have to learn. We don't have to devise another procedure. We just repeat the same for a lower number. We just the same as you do. You have groups like co-president, then you have groups like members of the board, then you have the treasurer, and then you will have the arbitration court.
Just a question which came to my mind at this very moment, because I can't remember seeing any provision on when the changes, if accepted, would come into effect. So would they come into effect immediately or at the end of the General Assembly?
That's a very good question, and I have no answer. As I get the question now, for me, the changes as when we announce the yes and the no's, and they are adopted, the statutes are changed from that moment on. That's my interpretation. Jakub, do you have some other interpretation, or anyone?
Does Belgium law say anything different?
So I'm studying French, and that's a bit the same as Belgian, or perhaps you know more about it. I can't really not tell you that, because that's quite a very detailed question. But Jakub, do you have any information on that? Jakub? Yeah, I'm sorry. Anyone else wants to share?
For a court rules, this is a very short paper, even though it looks long. One question which comes to mind is how will the court organize itself, and can he make his own proceedings, how he will make these decisions, for example?
Yes, I think that it will have to accept its rules of procedure as the same as board.
I think I remember there's an amendment later on vesting into the General Assembly the power to adopt procedures for the whole of the PPI, and if it's decided on regulations for the board or for the arbitrary court, then they could also make sub-regulations within that framework.
Yes, I agree.
So, thank you. Any further questions on this topic at the moment? Because it is an important topic. Otherwise, I would like to announce a short break for about 50 minutes. But before we do that, I've just learned some minutes ago, our dear friends from Tunisia are watching us at the moment, and so our greetings to Tunisia are given. Hello. Good to see you. So we see us in about 50 minutes, so I'd say 25 to 4. Thank you very much. So, dear ladies and gentlemen, I'd like to continue our discussion about the changing of the statutes. We're still at SAP 4, discussing about the arbitrary committee. So, are there any further questions on it arisen in our short break? That doesn't seem to be. I do.
It looks like many people use the two legs rule, or whatever it's called. So there is a better concentration, perhaps, I don't know. So shall we continue?
Yeah, well, I'd like to continue. As you can see, we have quite a lot of amendments or proposals in it up to now. Still grouped up in bugs, times and deadlines, legal technique and wording. So we do have some time, but I don't know if we want to use all the time of it. But I'd like to ask you which of all those proposals we want to discuss at the moment, because the most important we have had up to now, I would say. So what would you propose should we carry on bugs, times, deadlines, legal techniques, or something specific?
I think we should first fix bugs, then do the static change, and then the improvements, like a software.
Thank you. Any other proposals? None. So we carry on with the bugs. So that's SAP 5 bugs given from the Pirate Party of Luxembourg. The current wording sets out Pirate Parties International is not a political or authoritative entity. There are alternative proposals: delete the second sentence of the preamble, or change the second sentence of the preamble to the Pirate Parties International is a grassroots movement or similar sentence. Jerry.
First of all, I'd like to say I'm sorry for the pretty bad alternative proposals, but I still think it's an important change because, like you see at the moment, it says Pirate Parties International is not a political authoritative entity. There was quite a discussion in Brussels where people really wanted to stress that the PPI won't govern from top to bottom. So they wanted to put in a sentence that it's not a political body, but it should just be connecting pirate parties, and that it is not authoritative, so it cannot force parties to have this or that opinion on a topic. But when you read the sentence, it's, in my opinion, makes no sense because PPI is political. Our members are political parties. We act in a political way. Our objective is to get a political idea out there. So we're a political movement, and also we're authoritative because Pirate Parties International has statutes. If you're a member of Pirate Parties International, you sign or you accept the statutes. And if you're doing something against the statutes, Pirate Parties International has some means that are written down in the statutes that it can enforce, which means it's authoritative in a way. So my proposal is simply delete the sentence, or to replace it by. Okay, I see now why I put the two alternatives, because the first one that's from me, the second one that was from someone who proposed this same amendment right after the Brussels conference. So he said that he would like to replace this sentence by the Pirate Parties International is a grassroots movement. Any questions?
Not directly, but a comment on the second variant. The pirate movement is a grassroots movement. The members of the PPI are political parties which hopefully represent the grassroots movement as far as possible and as strongly as possible, but it's not the same. So I would rather support deleting that sentence for now.
Yes, also for the voting later on, I tried to have a look at the voting forms. I can't remind exactly how we managed this year, but we should have a look at it and see whether the alternatives are clearly marked. And if not, I make an announcement and trying to get this clear for the voters.
Just before here, when we had the secret break, the subject of authoritative entity came up. It would be just in the respect to the relations of the PPI members amongst each other and the PPI to the member, but not the PPI being able to practically force a member to act politically in this or that way in his state.
Yes, that's correct.
It's just to expand on what was just said. If I remember correctly from the Brazil conference, one reason there was so much support for this was that people were actually a bit afraid about what PPI was or was going to be and do, and this was why we actually added this. And I hope that this suspicion is going to be over now, that they can see how it's actually working.
Well, I think that the best example how it works in real was how we worked on the WikiLeaks proclamations and projects like that, which show how the political opinions are formed inside, like in the framework, how they are connected to PPI and global pirate movement. So it is, I think that this is the way how the opinions of all the pirate parties in PPI should be made, and we shouldn't be afraid of some of the board deciding to tell the pirate parties what to do, because that's simply not acceptable, right? And it's not. I don't think anything like that is contained in the statutes.
Thank you very much. I would agree to that. So any other questions? No. So we carry on. SAP 6 internal regulations, also given into by the Pirate Party of the Czech Republic. Change. Proposed. The current wording, the function of the General Assembly are, on H, to exercise other functions resulting from these statutes. And the proposal is to change it, except internal regulations for the Pirate Parties International, and to exercise other functions resulting from these statutes.
So the only the problem was that the statutes, there were basically two terms: the bylaws of the Pirate Parties International and the internal regulations of the Pirate Parties International. But from the statutes as they were written, it was not clear which of them, who does them, who issues them, because there were two clauses. It says that there were two demonstrative lists, one for board and one for the General Assembly, which means that if you have these two lists and each of them says and do other functions, it's unclear which of them actually accepts the internal regulations, which is a matter of great importance, I think, because the internal regulations they reflect the will of all the pirate. It's basically something quite similar on the level of the statutes, on the level of all pirate parties. It's not the board activity. It's not other organ activity. Is just something that the members gathered at the conference decide upon, without need to change the statutes.
Thank you. Everything clear or questions? No questions at all. SAP 7. Also bugs. Remote participation must be possible for all meetings of the General Assembly. That's the current wording in the statutes. The proposal is to change it into remote elections and voting on the points described in 11.2 shall be possible for all meetings of the General Assembly.
Okay, so this might be a bit controversial, but I don't think it's all that matter. The most important thing is that the remote delegates would have the say in the elections and the voting, where decide upon the factual proposals such as changing the statutes or declaration or so. But there are also procedural votes that are of course part of participation. At that's for instance motion for a break in the. There was I am talking about the last conference, there was a lot of work at the last conference. There were many votes, and I think that we should somehow have in the rules of procedure to be possible that in case it happens that there is no connection, for instance, for procedural votes that are not that important, that the assembly could could just vote on these procedural votes even without the remote participants. That's basically yes, yeah, I guess I leave that out for discussion.
Thank you.
I thought that it was already decided that if the remote voting didn't came in time, it was considered an abstention or a no vote. No. Sorry?
Today we have the deadlines, but that's part of voting, because also if you vote by raising your hand or your card, if you vote half a minute later and you raise your card, it doesn't count as a vote either. So the votes, we give them 1 hour to vote, the remote votes today. So we have 1 hour if there are any technical difficulties, and then after this hour, votes won't be counted. So today even remote votes can make procedural votes. That's why we have them on Skype. But as considering the structure of the conference today, there aren't any procedural votes, because we're not voting now on the statute amendments. So we don't need to ask them on the stream and on the remote voters, what do you vote now? So we can move on and to discuss them now, and then at the end we're voting. So that's why today we don't have procedural votes. So today it seems like that's already the case, but Jakub wants to have that in the statutes. So in case the next assembly decides to have another structure, a more strict structure, less flexible, where you have a lot of motions and a lot of voting, then there we are not forced to wait for remote voters if, for example, there's a motion to have a break, but that we only are forced to offer remote voters the possibility to vote for statute amendments, board elections, and annual fee. Is that correct?
Yes. These are the necessary conditions, which means that it will be decided in the rules of procedure what will the concrete situation be. But I think that if it's set like this, that the participation, if it includes all the procedural votes, it can happen, and it actually happened in the last conference, that all the remote participants were trying to make the speeches and the discussion as short as possible, so there was actually no discussion, because all the people who were in their homes, they wanted to cut it down, and the result was that the only thing that we were doing was voting, because everybody would like to finish as soon as possible, and there was no real time for considering the details of the statutes and their implications, and the result was that the proposals that were accepted were too rushed, and they were the result was not very good. So this was also, and I think Jerry can confirm this, that there was quite a pressure from the remote delegates to end as soon as possible and make the procedure as quick as possible when the statutes were being prepared.
Well, I was one of the remote delegates. I don't remember to having been so to having put a pressure on the assembly. However, I think that also on rules of procedure, the rules of procedure also have an impact on the remote voters. So I think they should be allowed to vote on this. For example, a break can also impact on them. For example, if they have a connection which is not reliable.
No, it's okay.
So, other questions? Nope. Yep. No. So we might continue. SAP 8. Still bugs. So it's Article 13, Clause 3 at the moment, which in its current wording states out, one natural person named by each ordinary member not represented in the board shall be admitted with the right to participate in the board meetings without the right to vote. So there are two suggestions, one given by the Pirate Party of Luxembourg, changing the article into, or the clause into, representatives of the members of the association must be allowed to participate in the public meetings, but without the right to vote. The proposal given by the Czech Republic, one natural person named by each ordinary member shall be admitted with the right to participate in the board meetings without the right to vote. Who wants to be first? Jerry.
Just to comment on the differences between the two proposals, Jakob can correct me if I'm wrong, but for me, the biggest change in the A and B proposal are that in B you have one natural person that must be admitted as board members, and in proposal A there's no number, so there could be more. And in my opinion, there shouldn't be any limit. Of course, if there are technical limits, I think that's not what this means. If for example you have a telephone conference and there can participate 30 people, then you shouldn't limit that to the board shouldn't be able to limit that to just one natural person. If there should be 2 people who want to participate or 3. You want to add something?
So I guess we should start with the current wording and what are the problems of the current wording. I actually was one of the people who wrote this current wording, so it's also my mistake, and I'll try to explain what I think the mistake is. It says one natural person named by each ordinary member not represented in the board shall be admitted with the right to participate in the board meetings without the right to vote. So I think the problem, at least what I saw, or what I think the problem is the phrase one ordinary member not represented in the board. I was afraid what the concept of being represented in the board means, because to the board you elect people who do not represent the members, the ordinary members. They represent the Pirate Parties International. They are by a different clause, which is in paragraph article 13.3. They are not supposed to be representing any region or other organization. So I think that the phrase ordinary member not represented in the board is misleading. I wrote it, so I have to admit that there was a mistake, and which I didn't quite manage to catch. And to the alternatives, there is the alternative A, which says that the representatives of the members may be allowed to participate in the public meetings, so that it doesn't extend to the secret meetings. I don't know whether what actually is the will of the assembly, whether the representatives of the members should be allowed on the public meetings only, or whether there should be imperative norm that would say that the representatives have to be included also in the secret meetings. This has to be determined. And to the complaint that the wording of the proposal B bans the board of to admit more than one natural person, I don't really think that this was the goal. It says one natural person named by each ordinary member shall be admitted with the right to participate in the board meetings. I think that what this is trying to express, it may be also a little bit misleading, so we can change the shall. It is an imperative norm for the board to allow. It means basically at least one natural person, so that there will be at least one representative. So perhaps we can correct that. I don't agree with that. This is the fact that you should if there is a mistake, I don't think there is any reason it's not written in the statutes that you cannot correct like stupid mistakes like this. Okay. Yes.
Just to answer the question, it is not specifically written down. No, but if I have a deadline to submit amendments, for me that implies that after the deadline, you're not allowed to submit any other changes and to modify. Also, changing a shall into a must or into a can is a very important change of a sentence, which isn't a minor change. So there again, you're really changing the wording and the idea behind the paragraph, behind an article. which I don't think is should be allowed by implication, that because of the deadline.
I have to say that and I think it's clear that the idea behind the proposed wording was not that there would be a limitation of the number of people that could be admitted to the meeting. So that I think that this and the change of wording, I think, is generally allowed. If there is a grammar mistake, I think that we have the right to correct it. And it was also at the last assembly, the board was authorized to do that.
That's correct. So you can, if you see that there's mistakes in this that are very minor, like you said, grammar or small mistakes, you can have the motion that the General Assembly allows the board, to call the next board, to make those changes in the statutes. That's what you mean at what we did last year. Also, just one comment on Jakob's idea about the one natural person. I agree with you there that it's not. It doesn't say it limits to one person. It just, for me, it's clearer that if you have the representatives with the S, that the board can, for example, not in its own rules of procedure say, okay, we're only allowing one person. So if you're having the A, that's not possible.
I would say if we adopted the amendment about the ability of the General Assembly to adopt regulations, it could adopt an according rule. That only one person per member is allowed. And then I've got a technical question. Let's say both amendments are accepted with 100%. What are we doing?
We already discussed that, and there will be an explanation how we will vote later on.
So, thank you. So, yeah, no problem at all. So, any questions on SAP 8? Nope. So, let's continue with SAP 9. Still the last, it's the last bug we are discussing. So-called bug. So it's Article 12, Clause 3. The current wording is, a member's affiliation ceases automatically upon dissolution, disqualification, liquidation, or in case of temporary administration, court-ordered settlement or insolvency. The membership also ends automatically when this member does no longer fulfill the criteria that were necessary for its preliminary recognition as a member. First proposal given by the Pirate Party of Luxembourg is completed as a whole, and the Pirate Party of Czech Republic proposes to change it into membership is automatically temporarily suspended upon dissolution, disqualification, liquidation, or in cases of temporary administration, court-ordered settlement or insolvency. So who wants to be first? I'd suggest Czech Republic.
Okay, so the current wording is a disaster. I think that's one of the worst mistakes in the statutes. So I actually said that even when the statutes were drafted, that this clause is dangerous and it doesn't make any sense. Unfortunately, there was no time to discuss this, really. What I tried to do is to alleviate a bit this mistake by just changing the automatic cessation of membership to suspension, which can make sense under certain conditions like liquidations, and so that it wouldn't disqualify the member by ending the membership, but on the other hand, it would make it would make the member report such important things that can have effect on the membership, and would leave this on the court of arbitration to decide what actually happened under the clause of matter of facts.
So my proposal is a bit more drastic. So I just want to delete the whole paragraph because I see a very big problem with automatic. So automatic means that it starts from the point where all these conditions are met. So whether you have You have liquidation, disqualification, dissolution, temporary administration. That means, first of all, you have to know what dissolution is, what disqualification is, what temporary administration is. Then you have to know under which law, under the national law, under the law of the where the Pirate Party International is registered. Then you have to have, which is very difficult sometimes to find out when these things happen. So when are you when have you a case of temporary administration? Does it have to be court ordered? Perhaps in some countries you can have a court order that says now there's a temporary administration. Sometimes it's just in practice the case. It's very, very difficult to find out whether the conditions here are met or not. And then another problem is who has to find them out, because it doesn't say the board has. The problem is we have voting here. We have the General Assembly once a year. 2 weeks after General Assembly, found out that 3 weeks ago there was a liquidation process started. Now we have to do the whole General Assembly all over because some member voted and his membership automatically ceased. So if you delete this paragraph, there's no automatic cessation. That means that it falls onto the General Assembly to decide whether the member is still a member or not. Or, as it says also in the statutes, the member can resign. I would have to check exactly what the statutes say on expulsion of a member, but if there really is the case, and at the moment we're having a case like this, where the Pirate Party of Ireland is starting a process of winding up, but to ensure you, they haven't started the process yet, so this article doesn't play. But they are talking about it, and they're saying, well, if nothing changes in the next few months, then we have to. This is, for me, it's pretty important to get the automatic out of the way, because it has a lot of unwanted consequences.
Like one example after Austrian law would be, let's say we were under liquidation, or we were liquidated, but we challenged it. Under Austrian law, every legal entity exists, even if it wouldn't exist otherwise, as far as it still has an obligation, it still is in a process of claiming its rights. So we would have been liquidated, but still we would be legally in existence because we were fighting the liquidation. Especially if the arbitrary court were adopted, I would rather propose deleting the whole part.
I agree with you on the term automatically. It serves no good, because there has to be a decision made. Either way, and so temporarily, automatically quits. You have to make this decision. So either way, and the question for me is who can make this decision. So is it the board or is it the court? And I think it would be wise to make that those decisions were made by a court.
The thing is, under the new regulation, it would be brought before the court, and the court decision could be challenged at the General Assembly.
Well, I have a problem with the word temporarily suspended. Is suspended defined anywhere in the statutes? What this status would mean, and who will re-enable them, basically?
Well, suspended, I think it's a legal term which says that you cannot exercise the rights anymore. Like it's not defined in the statutes, and I think that it would be very hard to define all those legal terms, and the result would be even worse. So what it basically means that if something in the list happens, such as liquidation, which means that money is drained out of the company, and something is done with the money. That's what liquidation means. Then under such circumstances, something special happens. Happens that there is a change in the I would say in the essence of the membership, and it has to be dealt with the court. So so it may happen, for instance, that there is a party, and there is a party that just stopped existing, and nobody really knows about that, and so it met the conditions under this clause, and it cannot happen that 4 years later, when this party stopped existing, there comes a delegate to the conference saying that I am from this party, I am representing this party, which actually nothing happened to that party, and I have a vote in the General Assembly.
Well, but I think this is also the sort of problems that even PPI should have had on its foundation, because at least every period party in a certain way was self-certifying itself. So I don't understand why this can be a problem because, for example, in the case you outlined, there can be cases where a period party can go to, how can I say, should have to disappear from public lights, for example, because of a regime or dictatorship. And so it has to work underground. So in that case, it's easy that from the outside, no one knows hear from them. Then maybe in this case we should later propose some safeguards for this. But in effect, I think that it's better to delete it than to try to readjust that.
Thank you. Any questions? Nope. So we finish books, and we come to times and deadlines. First of all, there's a deadline for ratification given here in SAP 10. There is no current wording at the moment, so that's a proposal to add an article into the statutes, which states the consent to these statutes emit no reservations, except the reservation of ratification from which the founding members may have made when signing the statutes. If the notification of the statute's ratification is not sent to the board in a 2-year time from the signing, the membership shall be considered never to exist. So, Czech Republic.
So what happened a year ago is that the pirate parties have signed statutes that had no provisions of effectiveness, which means that they became effective upon signing, probably. But certain pirate parties signed it with the reservation of ratification. That means that if an international treaty is ratified with reservation, it means that the person who signed it, like the president or the head of the government, has to go to the national parliament and has to have this treaty passed in the same procedure or very similar procedure as the law. So what happened, for instance, in the Czech Pirate Party is that the Czech Pirate Party signed the statutes with the reservation of ratification and went to the Czech Republic and sent it to the board, which has like 30 members who are representing the whole Pirate Party, and this board had to vote whether we accept the statutes of the Pirate Parties International. And in case we did not do that, it would not be you wouldn't be able to determine whether the statutes are binding for the Czech Pirate Party. In case we add this paragraph to the statutes, this will be clear that after 2 years when this reservation was not confirmed, that is, we sent the notification letter to the board, which said that our board consented to the treaty, and that it is now legally binding for us, including the procedure, for instance, to step out and so on.
This problem only is valid for the founding members, because all of the new members will probably have the rectification ahead. So the question is this regulation still needed? Are there any parties which have signed last year but haven't ratified it so far?
Jerry just left, but it would be Jerry. How is it with the? I know that at the conference there was very clearly said that every pirate party has time for ratification at the last conference. That means that they have internal process after which their board says whether they agree with the statutes or not. And I don't know what the results are, whether we got the notifications of the ratifications.
Partly. There were announcements made at board meetings where I remember from Luxembourg, from Germany, and I think I remember from Switzerland, that they accepted PPI membership. So from those we have notifications.
We send the Czech Pirate Party send a notification.
You do, okay. So there are some that already did it. Just I have to two things. First, I'm going to finish this one, and then I have to get back to some thing, because we have remote delegates who had a comment, who made a comment. I'm sorry if I didn't get that directly. You see, it's a short way to the laptop, and I only check it for a few minutes. So first, the SAP 10. There are two problems. The first problem is that it's a very good idea behind the changement, the modification. The second problem is that the wording can be very dangerous, because it says at the end, the membership shall be considered never to exist. So if a member does not send us the board a notification about ratification until the next year in April, so after 2 years after the Brussels conference, then all and each and every General Assembly that we had until then is void, because those members never had the right to vote. That's at least my interpretation. I saw him first, so I'm giving him the point first.
I don't know what it is under Belgian law, but under Austrian law, also only the decisions would be void where those votes, which should have never taken part, made a difference, or might have made a difference.
It is the same under Czech constitutional law, and I think it's the only reasonable way how to actually deal with something that is null and void. That you have to look under the concrete circumstances. It's not enough that if one person takes part in the elections, where 10 million people, 10 other million people are taking part, and if that person didn't have the voting right, that's really not a reason why to declare the elections null and void. And second thing, it needs to be declared to be null and void, which means that there has to be competent body to say that the elections were null and void, which now is not the case. So in case if there were the court of arbitration, that would need the decision of the court of arbitration.
I mean, if we include the court of arbitration, we will have the possibility to mediate first if we have that problem that someone is not ratifying, and we can still exclude him via the General Assembly. And it will be this rule will be not necessary in the future, so it's a bit strange to include it in the statutes just for probably 3 or 4 cases which are left from those which are probably all solved without the problem. Yeah.
you've got to do your stuff properly, and if you have a proper documentation of what is the case, it's better than having a void and then problems stemming from it.
Well, it's very hard, like, for me to sit or to imagine that I would sit in a place with parties that I don't know whether they are members of the PPI or not, and this sets a way of very clear distinguishing whether they are, or at least it says the procedure to say if that member is a member or not. I don't think that it's proper to consider the expulsion or it's not expulsion, exclusion of a member, this procedure to be used for forcing members to ratify the statutes.
The founding members, you meant, yeah. Just for the remotes to let them know. So I'd like to continue because, last.
So it was pointed out by the people watching the stream, so the remote delegates, that they are not very happy with SAP 8 participation in public meetings of the. No, I'm sorry. Which one it was about the remote delegates? Precision on remote voting. Yes, SAP 7. So the change would be remote elections and voting on the points described in 11.2 shall be possible for meetings of General Assembly. So what we discussed about remote delegates having, as I'm quoting, having a lesser voting power than physical present delegates. So there were comments that they wouldn't like that very much. So just to point that out and to put that into discussion.
The problem is, to some extent, there are two ways of reading the sentence. There's the way of reading it that absolutely, positively, definitely, at least on the 11.2 subjects, the remote vote has to be possible at any condition, not excluding remote voting on other matters. And the possible reading it like reducing it to 11.2 matters.
Okay. Let me. Okay.
Sorry, that would be one point to straighten out in the regulations, I would say.
I just checked, there are no new comments, so we did just put that into discussion. Just one technical proposition for me, so it's getting a bit late. There are a lot of technical amendments coming up, so I would propose that we take 2 minutes each and we look into quickly look over the amendments, and then everyone says, we try to find last 3 or 4 amendments that we're going to need to discuss, and then we discuss those. If everyone's okay with that.
So have a look at it. So there are not that many of them left, as far as you can see.
I at least want to say something about that, because I will, for the next General Assembly, certainly will have an amendment for the future that discussion like that will not be possible anymore. That is not really the right place to discuss far-going changes in our statutes, our base rules. Everyone here should basically join this discussion. This should be done in the plenum. And now we also skip probably a big part of the discussion because we are in this form, and I think this is not the way to do a General Assembly.
So thank you for your words. So have you had a look up to now into the last 10 proposals? So it's still SAP 11 to 21. That means deadline for application, deadline to send out amendments, going into legal techniques and going on with deadlines. To send out the amendment again, abbreviation, goals, support, not unify, board's action, a majority of members, goal, no purpose, member organization, member inconsistency, bylaws, numbers and alternatives, board members clarification. Just have a short look into all of them.
So perhaps to respond to the comment, I'm modifying my proposal then, and I propose that we're not starting with reading everything out, but those who propose the amendments will present the amendments, and we shouldn't have any
You are right. Most of the stuff which will come now is technical, and I'm not against it in general. I just was complaining about the form, not about the proceeding itself.
So we still proceed. Have a look at it, and any question arising, just give and ask.
Okay, I would like to say something to the statutes amendment number 23, which is at the very end, and I would like to stress why it is important, at least for us. The current, in technical sense, how you quote in the statutes now is that you write it without the quotation marks. It's when it says the name of the association is Pirate Parties International. There are no quotes, and I think that this should be reflected also in the provision that is related to the word pirate. I think there should be no quotes, and I tell you why. In the Czech Republic media, we had big problems that they are destroying our name, our brand, which is pirate. They call us pirates with, for instance, small p, and they quote us, and they put quotes around the word pirate. They make it relative, but we are not pirates in the quotes. This is just this looks degrading for us, and we would like to avoid the use of the so-called pirates or whatever. They don't even know whether they are pirates or not, so we would really like to change it to the pirate with capital P, because that looks much better in the media. It presents us in a much better way than pirate in the quotes.
Is there a comment concerning that? If not, I'm moving on. Okay, so comment about SAP 22. So here we're changing Article 12.3. Other positions including but not limited to social media and grassroots officer, translation and news officer, chief technical officer, ideology leader may be created by the board. These examples are misleading, I'm writing, but I also think that's quite strange example, like ideology leader. I can't remember exactly how that came into the statutes, but you don't even know what it is. And if you put in other positions may be created by the board, it's like a distribution of competences. So if someone from the board is responsible for social media, the board can put that in the minutes and call him from now on social media officer. So it's not a change in any voting power. You can't add anything. You can't change the way the board is organized. But in this amendment, the board organizes itself and just gives names to those people. And I want to get rid of the enumeration, because also it says including but not limited. So it's already in the paragraph that you can create other positions. But the examples, if they're there, they imply that perhaps the board should have these and the others only if necessary. And as the examples are not very important, very good, I want to get rid of them.
I actually never quite understood what the article was supposed to mean, But now I think that what you think, what you say it means is that the positions are created inside the board. It's just labeling the one member of the board by certain position like social media, blah, blah, blah. So it cannot be a position outside of the board that the board would name person outside of the board.
No, because you have to read the article in conjunction with the statutes, and nowhere because it says the board is elected and the board has the powers, but the board has not the power to create a position that has a voting power within the board. So you can't find a loophole where the board could create something new out of this article. So it's just because it's in there and there's the enumeration. I want to get these ideology, Liga, and social media stuff out of the statutes.
What about task forces? Are they are created by the board? Definitely, like I don't think they are dealt in the statutes with at all. Are they? So I think that they are not. So this would task force be an example of a position created by the board?
Yes.
Under this provision?
I would have to read the whole section, because also that sometimes has an impact on how you read the article. But in an isolated view, yes, it means that the board has this article gives the board the power to say this guy or this person is the official PPI WikiLeaks task force leader. That's a position. So that doesn't mean that this position has any voting consequences or so, but it has it's more official. It's officialized also for you can send, perhaps if it's a specialist, you can send the media to them instead of the board. If you have, for example, WikiLeaks or a task force, an index task force, it's an official PPI position, but it's not something that adds to the statutes or so.
Provided not somebody pops out some new provision for the General Assembly to decide tomorrow. Sorry? No, provided that the General Assembly doesn't decide on a rule how task forces are being created.
Yes, of course. The General Assembly can always put a motion in and have say the board has to nominate a technical officer. So that's yeah.
For example, we could decide tomorrow that task force might be created by the board if 2/3 of members agree, or half of members agree, or whatever.
Of course, yeah. Of course, yeah. That's the power of the General Assembly, that can accept motions and vote on it. So, yes. Were there any?
Is it in the statutes?
So that was just a check-up to see if are there questions from the remote delegates at the moment. So any other statute amendment proposals we want to discuss at the moment, or any questions about them?
Well, my question is more about voting technique and so on, because in some of these amendments, we actually have two alternatives, A and B. So we could either vote for A or B, or against both, or abstain. And it seems like, at least in the form we have here, with my prospective vote, we just have yes, no, and abstain. So I'd like to know about how we're going to vote about this.
The form your party got for voting will have 2 yes, no, abstention lines, one for A, one for B. Since both proposals can be accepted by a 2/3 majority because you are allowed to vote yes for both. It means that you have to answer a third question, which basically means if both votes are accepted, which one would you prefer? So you will say yes for A, yes for B, and you will add a third line which says A or B. And if both will be accepted, the majority of the third question will decide which one we accept. A tie in the third row, then we will have a discussion in the plenum, I think. But usually the guy leading the meeting will decide then.
Yes, I think that there is one more problem, that is that if some amendments are voted, are accepted or not accepted, this can also change the view of some members on other amendments.
That's why I don't like this form, but we will just have to live with that in this vote.
But technically, each amendment stands independent from each other. And technically, if some of the new regulations were adopted, there would be enough provisions to make things work.
So, thank you again. Any other questions at the moment? If not, I would like to close the discussion itself, hand over the microphone to Jerry so he can state out even more about the upcoming votes. Short break.
Just so you can inform your delegations too, we're going to try to put in the third question. So if there's A and B, which one do you prefer? We want to put it on the form, and we will make a copy of that and try to distribute it. And to add question 5 where we omitted the A and B answers. So we try to do that now, and then we'll have another information for everyone else. Okay, thank you.
So thank you all, and I'd say closed. Thank you very much.